Good afternoon, everyone. So, in this video, we are going to talk about two cases. The first one talks about the firecrackers. As you know, the Diwali season is going on and there are firecrackers all around. So, let us discuss the constitutional provision for the firecrackers. So, the use of firecrackers in the National Capital Region, that is the NCR, it is unconstitutional. The use of fireworks in NCR is a major source of noise and air pollution and is also causing immense harm to lives and health of citizens. The duty to ensure healthy environment not only falls on the state under Article 48A but also on the citizens under Article 51A, that is the fundamental duties. The central government in public interest has been directed to suspend all licenses to store that sell firecrackers within territory of the NCR. This landmark case was Arjun Gopal versus Union of India, AIR 2017, Supreme Court 173. So, what was the Supreme Court's ruling in this case? In this case, the Supreme Court imposed a ban on certain types of firecrackers to mitigate the environmental harm. Though the court allowed some uh, use of less harmful crackers, aiming to balance public health and environmental concerns with limited freedom of trade and religious expressions. So the primary issues dealt in this matter were firstly right to trade and profession. That is Article 19(1)(g). The businessman argued that the ban violated their right to freely trade firecrackers. Second, it was right to freedom of religion, Article 25. Some claimed that the ban interfered with religious practices associated with the firecrackers. Third was right to life, Article 21. The court emphasized the fundamental right to life, prioritizing the right to a clean and healthy environment. And the last was environment protection obligation. The state's duty to protect the environment and citizens' responsibility to contribute to this protection were also considered. So, this is how Article 51 comes into play. Article 48A obligates the state to protect and improve the environment, while Article 51AG places a duty on citizens to help preserve it. These articles support the firecracker ban, emphasizing a shared responsibility for maintaining a sustainable environment, which includes reducing pollution from the firecrackers. So let's talk about the fundamental duty, that is 51G, to protect and improve the natural environment, including forest, lakes, rivers, and wildlife, and to have compassion for living creatures. So there was a question that does this ban apply to all firecrackers? No, the Supreme Court's ruling in Arjun Gopal prohibited certain categories of highly polluting firecrackers while allowing regulated use of less harmful varieties. This approach seeks a balance between public health, environment sustainability, and limited freedoms of trade and religion. So, this was all about it. Now, coming on to the second case, it was the Ramlila Maidan incident that happened in 2012. So there was a protester sleeping in the Ramlila Maidan, and around at 12:30 p.m. the police came using water guns and tear gas. they they had the orders to evacuate that ground. So that caused many injuries and deaths. This case discussed the imposition of Section 144 of the CRPC and examined the procedural safeguards which would have to be followed. The court reaffirmed that passing an order under Section 144 was not violative of the freedom under Article 19. It also held that taking prior permission for holding protest would not infringe the fundamental rights enshrined under the Article 19. This would fall within the ambit of reasonable restrictions contemplated under Article 19.2 and 19.3. So, in this present case, the court held that there was no imminent need to intervene, and therefore the restriction placed by the imposition of Section 144 was unreasonable and that was unwarrantedly executed. The court accordingly ordered for the criminal cases to be instituted against both the police and the members of the protest who indulged in destruction of the property. It also ordered disciplinary actions against those police personnel who resorted to excessive use of force and who did not help in the evacuation of the people from the ground. So in this case, it was a right. There was a right, that is right to sleep, that was talked about. In Article 21, right to life, there is also right to sleep. That is, in this case, the Justice Chauhan, Honorable Justice Chauhan opined that the actions of the police infringed upon the right to privacy. He observed that the right to life envisaged the right to sleep peacefully as well, and any unjustified intrusion would amount to the invasion of privacy, which he recognized to be an essential facet of the right to life and human dignity. It is evident that the right to privacy and the right to sleep have always been treated to be a fundamental right, like a right to breathe, to eat, to drink, to blink, etc. So, in this case, the right to sleep was talked about. Thank you, friends, for watching this video.